Thank you, everyone. Please be seated. We are here today, this morning, for submission of 4 cases. The case of Emilio Puente and Civil Service Commission of Iowa City is hereby submitted without oral argument. Our first morning oral argument is Rivera versus Clear Channel and others. It looks like the parties are ready, and it's my understanding, Mr. Cornell, you're going to go first, and then Mr. Schuler will do the rebuttal. Okay, thank you. And Mr. Reisner on this side. Thank you. Okay, Mr. Cornell, you may begin.
Thank you, Your Honor, and may it please the court. Counsel. My name is Manuel Cornell, and I, along with my co-counsel, Mr. Schuler, who will be arguing the rebuttal part of our argument, we represent the plaintiff appellant in this appeal, Mr. Medardo Rivera, who is in the gallery with us today. The district court incorrectly held on summary judgment that the statute of limitations ran against defendants' appellee's grant of perpetual easement, regardless of whether the purported easement was void ab initio. The district court's ruling is wrong for 2 reasons. First, the easement is void ab initio. Second, the statutes of limitations under sections 614.1 and 614.17a cannot legally, or as a matter of public policy, apply to void conveyances. On the first one, the easement was void since its inception. As the facts show in the record, Mr. Rivera purchased the property at issue on contract on February 11, 2008, from a company called On the Wall Painting. Effective the next day, on February 12, 2008, On the Wall executed a document titled Grant of Perpetual Easements and Declarations of Restrictions in favor of defendant Clear Channel. This was later assigned to another entity called CCOI Holdco Sub 2 LLC, ultimately assigned to defendant.
The easement have like 2 different dates. One of them is the 11th and one is the 12th.
The easement was signed on different dates, but the effective date on the easement, which is on the first page of that easement, is February 12, 2008.
Agreement, paragraph 5H, there's a reference to an easement purchase agreement dated August 17th, 2007. What does the record reflect about that purchase agreement?
I don't believe that is in the record, Your Honor.
What are we to do with this paragraph that indicates that there was a purchase agreement in August of 2007 that predated the actual recorded instrument?
I believe that is the defendant's burden to show that they had some type of right before this easement, and they did not. And in any event, this was not recorded before the contract that was executed on February 11 in favor of Mr. Rivera that granted him rights to his property.
But if there were a purchase agreement in August of 2007 that predates the installment contract with your client, and the grantor in that case still would have had authority to enter into that easement agreement. Is that right?
Presumably, Your Honor. But again, that is not part of the record.
You said that the purchase agreement or theoretical purchase agreement was not recorded prior to your client's entry of his purchase agreement for the property, right? The easement purchase agreement was not recorded. Is that right?
The purchase agreement, the contract for the purchase of the property, was not recorded before the easement was deemed effective. It was recorded days later. That's correct. So because On the Wall had already given these rights to Mr. Rivera, our equitable conversion doctrine, under that doctrine, Mr. Rivera became the sole owner of the property at issue with all real estate rights the moment they entered into that contract.
What are we to make of the delay in your client bringing action on this? Why was quiet title brought when it was? I mean, obviously these billboards had been there a very long time.
Your Honor, on 2018, before the 10-year expiration of A statute of limitations 17A, Mr. Rivera obtain a warranty deed for his property, and that was recorded. Later on, he started wondering why these signs were up there, and figured out that they were on the edge of his property, and he figured out that they were within his property. But again, those factual issues have now been developed in the record below. So at this moment, the only thing that on the wall retained was a title to the property, a security for the contract that, and as trustee for Mr. Rivera. In other words, at this moment, on the wall had no bundle of sticks and no authority on the following day to issue this easement in favor of Clear Channel. Plenty of Iowa authority and out-of-state authority support this proposition, but also common sense supports it. Someone cannot convey to someone else something that isn't theirs and which they don't have authority to convey. Now, if the opposite were true, people could simply create real estate documents, file them with the recorder at the recorder's office without the rightful owner's notice or knowledge, and then wait out the statutory period and then claim victory on this new property.
614.17A, a marketable title act, or is it a curative act?
Thank you, Your Honor. The case of VOD, which was recently filed and which the defendants brought to the attention of the court, calls it a marketable title statute. However, the statute under that chapter is divided into three separate subdivisions. The first one is a statute of limitations. Second one is a special statute of limitations. And then the third one is marketable title statute of limitations. 17A falls under special title statute of limitations. And then there's others under marketable title, which the VOD case references is 614.31, which provides for a 40-year limitations period.
Your period was in play. Does the fact that, or your argument that the conveyance was void apply? Would that argument apply to the 40-year statute? I'm sorry, it's not a very good question, but does the 40-year statute under 614.31 prohibit, or would it come into play even if there was a void transaction?
Presumably, Your Honor, and that's why it falls under the marketable title section of the statute of limitations, because again, public policy dictates that at some point we have to have marketable title, and therefore the legislature was smart to divide them into chunks, and it put it under the marketable title section of that part. And again, under public policy, that would leave the court the option to then use that statute to apply to void conveyances and not have void conveyances just be of record title forever. Now, appellees argue that the easement is not void because they are good faith purchasers, and therefore the easement is valid, or at most, it should be voidable. But Iowa law is clear that the good faith purchaser doctrine does not apply to void instruments. And that is the case of LSV Peck, which we cite in our briefs from 1876. In this case, this court recognized that a void instrument does not provide title to a good faith purchaser. And plenty of other jurisdictions hold the same, as we cite at footnote 1 of our reply brief. Again, the easement here was not valid or even voidable, but void ab initio because on the wall had no authority to convey it. Our second argument that the statute of limitations under 614.1 and 17A cannot apply to a void instrument, and that the Hoard case is not applicable. Regarding Hoard, that case involves quitclaims deeds that were deemed by the court to have been valid at the time of Lois Hoard's death, or they were voidable before her death. So these deeds had validity throughout their existence, and this court held that the statute of limitations applied to them and that the elements under section 614.17A were met. But nowhere does this court in Hoard hold that the deeds were void at any moment. And just recognizing the arguments of the beneficiaries is not holding that the deeds were indeed void. Appellees argue that without a doubt, the Iowa Supreme Court in Horde ruled that even the alleged existence of a void transaction does not preclude application of 614-17A. But that ruling simply does not exist in Horde or really in any other Iowa opinion. The facts in Horde are largely inapposite the facts of this case, and that is because the easement at issue here was never valid or even voidable. It was void since the beginning because, again, On the Well had no authority to convey it. Moreover, a big distinction between Horde and this case is that in Horde, the beneficiaries themselves were the grantors of the deeds that then they were later challenging, whereas here, Mr. Rivera never granted anything to anyone. So Horde simply is not applicable in these circumstances, and this Supreme Court has never held that the statute of limitations under 614.1
Turned on this voidable versus void distinction. I agree you can distinguish the facts. I mean, the point that Horde was making is, that I think Justice Appel was making is, you know, the claimed interest in the real estate has been spread on the real estate records for more than 10 years without dispute. And that's the situation here too, right?
Yes, Your Honor, but again, the distinction is that it was never deemed whether it was voidable or void. And so that question is still open, which is why we're here before this court, whether that statute of limitations applies to a void instrument.
Is your client, though, in terms of claiming it was void, claiming the transfer was void? I don't see a distinction.
Mentioned, Your Honor, the distinction is that in that case, the deeds were deemed at one point valid, and then in other instances voidable, whereas here we argue that the deed or the easement was voidable. And then another distinction is that the beneficiaries themselves, who were later challenging these deeds, they granted those deeds, whereas Mr. Rivera in this circumstance never granted the easement and in fact didn't know about it for a very long time.
About what your client knew about the giant billboards and who owned them or anything about that?
Other than arguments from the defendants. But yeah, the record is not developed as to those facts.
Not the easement was possessory.
Thank you, Your Honor, for that question. This court has held that 614-17A serves as a bar to enforce a possessory interest in real estate. But guidance from our United States Supreme Court has held that easement is a non-possessory right, and therefore that's one of the elements that defendants failed to meet under 614-17A, which we also believe that the district court got wrong, because that is not a possessory right under the statute.
Interplay with the argument under 614.1, sub 5, the 10-year statute of limitations there.
Thanks, Your Honor. So 614, we've always argued that that statute also does not apply for two reasons. One, again, the easement is void ab initio. But secondly, that is a statute of limitations to recover real property, and this is a quiet title action only. So we would argue that that statute of limitations simply does not apply.
Just from a very practical point of view, that what you are trying to do is recover any rights there are in this easement area or the billboard area, however you want to define it. I have trouble saying that there's a real difference between those two things, and maybe you can help me.
The action that was brought by Mr. Rivera was simply to clean the title, and it was never to recover the property, and that is not part of the record below, and it was never developed. So I would argue to this court that that's really not an issue in this appeal.
Limitations applies to his cause of action.
If the court were to put a statute of limitations, we would argue that neither 17A or 614.1, which is the defenses that the defendants have raised, apply in this matter. And as a matter of public policy, as I repeat, if this court wanted to put a statute of limitations to prevent or to support marketable title, that would be under the subheading for marketable title statutes of limitations, which is 614.31.
649.8 on quiet title says that the act shall not be construed to remove the bar of any other statute of limitations. So it seems like there's some statute of limitations that applies. Which one is it? Is it only the Marketable Title Act, or which of the 614.1 statutes of limitations would apply?
If the deed were to be, the deed is void, as we argue, and we would argue that it's the longer statute of limitations that applies, but because the deed is void since its inception, 614.17a and 614.1 simply cannot apply, and this court has held as much with void tax deeds. Your Honors, I see that my time has expired. May I conclude my remarks? So the deed is void ab initio, and the statute of limitations under 614.17a and 614.1 simply cannot apply. We ask that this court reverse the ruling of the district court and find that those statutes of limitations do not apply to Mr. Rivera's claim against defendants because the easement was void ab initio. Thank you.
Thank you, Your Honor. May it please the court. This case is a perfect example of why title clearance statutes are important, and the district court's analysis worked exactly as the legislature had intended. When all the elements of section 614.17a are met, all claims concerning an interest in real estate are extinguished. The district court correctly found all the elements applied in this case and properly determined that Mr. Rivera's claims were extinguished. The district court's ruling should be affirmed.
Let me ask you a little bit about 17A and the requirement of being in possession. I think Justice Oxley was raising the issue of whether or not easements are possessory interests. The district court sort of took more of a plain language approach to the in possession and said, you know, you've got gigantic billboards here. But I am concerned about the fact that easements, you know, a lot of times we do say they're non-possessory, so help me with that.
Practically, I don't know how you can say that a billboard that has been driven into the real estate since at least 1980, there's concrete footings, nothing else in the world can occupy that space except for that sign that's been there at this point for 44 years. I don't know how you can say that that's not in possession of the real estate. Now, the statute requires the subsection B. This action is against the holder of the record title to the real estate in possession. And so,
Rivera, you know, wanted, if your client wanted to open a coffee shop at the bottom of the billboard on the ground, Mr. Rivera could kick them out, right?
I don't recall exactly what the billboard or the perpetual easement would say, but I would assume that the easement limits the use to an advertising device. And so most likely no coffee shop can exist at that point because there's the limiting language in the scope of the easement.
Of the difference between possession and use, you just said that the easement grants your client the right to use it, and it might be perpetual, but it's still only to use, maintain, construct, repair, dismantle, replace, alter, improve, operate the outdoor structures. Does the easement itself give your client the right to exclude, Mr. Rivera?
Yes, it does. The easement is, the easement does give exclusive right to Lamar for that.
Right to use the property, but does it give your client the right to exclude Mr. Rivera from the property?
It would give, on the point where the easement is located, where the sign is located, yes. It's a perpetual right for Lamar to have its sign on the property at this point, yes. I
Interfere with your use. I mean, he could go stand under the billboard. He has title to the property, right?
under the face of the billboard, we can't stand underneath the foundation of the sign that is,
It prevents the title holder from standing underneath a billboard on his property, because I don't see that in the deed.
dig underneath of the ground, go underneath the concrete footing, and then dig horizontally. I mean, the sign, the
Possession to mean kind of physical occupation. So let's assume that Lamar or its predecessors had the easement, but they decided that the billboard wasn't economically feasible anymore. They didn't want to maintain it, so they tore it down and quit using it. So are they in possession then?
if they removed their structure, they would not be in possession at that point in time.
Let's assume that next year they decided that it was no longer feasible to have this billboard. They tore it all down. Everything's going digital. They don't want billboards anymore. What then? So the statute of limitations apply now, but it doesn't apply next year. And if they decide to build a billboard again, then the statute of limitations runs and it just kind of turns on and off depending on whether or not you have a billboard there?
I honestly, I don't know. I guess I've not done the analysis on whether they remove themselves from possession. Does that pause or toll the statute? Would it start anew when you come back in? I don't know the answer to that question, but I do know that these signs have been in place since at least 1980.
If the test is actual physical occupation, then it has to be the case that what you're saying is the statute of limitations turns on and off depending on whether or not they have a billboard there. And I'm asking that question because it seems to me that can't be right. And if that's not right, then give me an interpretation of the statute that works.
I don't think that that can be right. I guess an example of why that wouldn't work, let's take the example of instead of Lamar being an outdoor advertising company, they have derived their title and they have a homestead on the property. They're residing on the property. I'll remove the term homestead. They reside on the property. They're obviously going to leave the property at some point in time. They're going to go to the grocery store. They're going to go to work. They're going to come back. And so they have left the physical occupation, but in every...
To easements. I've never seen an easement to construct a physical residence on somebody else's property. That seems more like a lease or something else. And then let me ask you this. Let's assume you have a non-possessory easement, just like a right of driveway access. That's completely non-possessory. How does the statute of limitations apply to that? And so does this 614-17A apply differently to possessory versus non-possessory? Easements appurtenant, easements engross. How do we navigate that?
The holder of that easement would likely not be in possession because they're not occupying the real estate. If all it is the right of ingress egress over a certain space, that's not occupation. We have a sign here that's been here for 44 years at this point. Think of a wind turbine easement or easements for transmission lines across property. There are physical occupations of the ground, but we would still call those rights easements because it's not holding every stick in the bundle of property rights. It's not fee title, but it's the right to have, if the purpose of the easement is for a transmission line, a turbine, a sign, you have that stick in the bundle to possess that specific portion of ground for the purpose of the easement.
So what you're saying is where we should read holder of the record title to the real estate in possession to mean the of various possible record title holders, the one that's actually in possession of that particular bundle of rights at that point in time is the one. Is that what you're saying? It's sort of a notice concept.
And it's the same type of concept that we would see on the offensive side of a prescriptive easement, open and notorious hostile use. You know, it's something is there, and the world knows it's there. Mr. Rivera knew these signs were there when he entered into his real estate contract. They had been there at that point for more than 28 years.
I want to clarify. I think Justice Mansfield said it was right, but you're saying in possession means actual physical possession and occupation of the property. Is that correct?
I apologize if I misunderstood that. I'm not saying that exactly. I'm not saying the owner of the right, but the person who derives their ability to do what they are saying that they can do on the property. I have the right to put this sign up on the property by virtue of this easement. That easement is
Right, because the first part of the statute says the record title holder. So that would always be the owner of the right, and the kind of in possession would go away.
in possession is you are possessing the property by, you know, you're possessing the property. And the other element is record, excuse me.
I think what I mean, it's not your job to clarify misunderstanding across the bench, but I think what I'm getting at is that what may be a possible interpretation of the statute is there can be various record title holders. That's why you're in litigation anyway. But the statute would only run against a record holder title who is actually possessing whatever actually actively possessing whatever that title is. So somebody has an easement that they're not using, can't rely on this statute.
Exactly, and that brings up a point that I wanted to tie this back to. So Mr. Manuel conceded that the 40-year marketable title statute would apply to cut off potentially void deeds. And then he also raised this hypothetical of, well, we have to stop people from creating these clearly fraudulent deeds, waiting 10 years, and then saying, oh, wait, gotcha, I own the property. That's the point of the in possession. It's the notice to the world. The hypothetical that Mr. Manuel raised about someone surreptitiously going in and creating this conveyance, the protection against that is that it has to be the holder of the record title in possession. And so Mr. Rivera is going to know that he needs to take some action within 10 years to clean up the title, as he says. He's got to go do something.
Ask you another angle on this. How does that work with 614.15? If we're going to apply that in the alternative, as you've argued, it doesn't have the in possession language, but if I understand your argument about it, it might be that runs off a discovery rule, and like most statute of limitations do, and here we've got the billboards, and they've been there since at least the 80s or however long, so that would be enough to trigger that limitations period as well.
That section would apply here. The Chaddick case from several decades ago, the numbering of that 614.1 sub 5 was a different numbering, but the Chaddick case said that quiet title action needs to be brought within 10 years, Your Honor, yes.
About how Lamar would protect its rights. So let's assume Mr. Rivera says, I don't think this easement's valid, and he went and tore down the billboard. What would your client do?
I guess sue for conversion, breach of the easement, tortious interference. I guess there's any number of claims.
Without litigating the underlying validity of the deed.
Well,
Me, at some point, as between competing property owners, whatever the claim is, each of you needs access to court to resolve the dispute about the validity of the easement. And if you're saying nobody has recourse, I mean, at some point, the deed and the purchase agreement, the easement has to be determined whether it's valid or not. And he could tear down your billboard, and then what do you do?
We don't see that context when there's a dispute about boundary lines. If something has, if there's been some type of question about the underlying conveyance from the 1920s, you don't go back that far. We've got the marketable title statute for a reason. What it shows up.
You do if he tears down your billboard.
I think, well, we would bring a claim for some type of interference, whether it's tort or contract based. And to the extent that they would raise the defense that we don't have an interest, we would say we absolutely have an interest. You don't have any right to question our interest because you let this sit for more than 10 years. That 17A applies.
Could he bring a trespass action? And he says that your billboard is trespassing on his property. And then you would have to make an affirmative defense that you have the easement. And then the court would have to litigate the validity of the easement. It seems like all the roads lead to some court somewhere has to determine the validity of the easement at some point in time.
Trespass action would be an action to recover an interest to real estate, which would trigger, if the conditions under 17A are met, we're going to say that you can't bring that claim because your claim for that trespass has been extinguished.
But every day is a new trespass. Every day the billboard sits on his property. If you don't have a right to be there, that's a new trespass.
My time is up. May I respond? I think that this court would still look at the fact that the sign has been in place since 1980. And I don't know if it would say that every day a new statute of limitations begins. I think that the trespass, if there would have been one, would have had to occur long ago. So I don't think that that's going to continually update the beginning of a statute of limitations, just like if you're in a car accident and every single day your arm continues to keep hurting, you're suffering the same damage, but that doesn't mean that the statute of limitation is going to keep reoccurring every day that you're in pain as a result of that accident. Your Honor, my time is up. Again, we do request that the court affirm the district court's decision in this case because it properly applied the facts to the law. Thank you, Your Honors.
And Mr. Schuler.
Thank you, Your Honors, and thank you for the opportunity to argue before you today. Mr. Reasoner started his argument with saying this was a perfect example of how the marketable title statutes can be in play. I would disagree with that, of course, and I think it's for a lot of the reasons that we've been focusing on in possession here today. If this were a perfect example of a marketable title statute in play, it would be a perfect example of cleaning title, not creating title. This is a void easement due to the equitable conversion doctrine. There's no way under Iowa law that we could hold otherwise. And if this court were to apply the statute of limitations in the way that Mr. Reasoner and his client is suggesting, you would be creating title, not cleaning title.
All right, let me follow, Mr. Schuler, let me ask you kind of where I was going earlier. One way to interpret this subsection B is that it only protects people that hold what are commonly regarded as like a possessory interest as opposed to other types of interests in real property in that category. Another way to interpret it is that it protects people who hold a record title if they're in possession of whatever that title gives them. And that seems to me maybe a more logical way to interpret because, I mean, the billboard's been there since 1980. From the discussion, I think Mr. Cornell almost suggested that Mr. Rivera didn't actually initially believe the billboards were on his property, so he didn't You know, it's not that he thought that he was getting title to those billboards. And this seems to me like the kind of situation that a marketable title action ought to protect against. So help me.
Try. I don't.
Questions like Justice Apple used to ask.
I don't think you can, in these statutes, disconnect the record title part of that subdivision, or subdivision B, from in possession either. It's the element for 17A, and that second element is the record holder of the title in possession. An easement, and this goes back to the Brandt United States Supreme Court case that we've cited and is recognized throughout property law. An easement is non-possessory. It's a non-possessory right. It's not a title right. You know, we may think of an easement as part of the bundle of sticks. Yeah, it's a bundle of sticks, but title is ownership. It's what do you own? And in this case, Lamar, as if we assume that they have a grant of perpetual easement, as they've argued, that's not record title in possession, because an easement is a non-possessory right. And the only record title holder here is Mr. Rivera. He has not only the installment contract, which gave him equitable title, but then within 10 years later, he actually has a 2018 warranty deed. Mr. McDermott, you were recognizing, doesn't this basically boil down to competing interests, competing documents? Aren't we eventually going to get there? And I agree, we are there. Mr. Rivera, he's got a warranty deed that from 2018, most recently, that says there is no easement. And it's from the same person that gave him the installment contract in 2008. So I don't think we're in a position where you can say the record title holder in possession is an easement holder.
Easements are sort of per se not covered by this statute.
It's really tough to argue even, or to find a statute of limitations in section 614. I mean, I wish the legislature would just replace chapter 614. It's a mess.
And then, and I don't want to put words in your mouth, but it kind of sounds like you're talking about the idea that Mr. Rivera could have waited another 100 years with these billboards and then brought his claim, and there'd be no statute of limitations that would prevent that.
Hypothetically, I mean, what I can say and argue here is that the statute of limitations that are in this case and that we've argued, they don't apply. You know, Justice Oxley, I know your Vought decision raised the section 31 with the 40-year statute, you know, and there's a debate, well, does that apply? Could that apply even to a void deed? You know, I don't think you have to conclude that. Maybe it does, maybe it doesn't. It is a marketable title statute, section .31, and it's actually in the subchapter of chapter 614 that is entitled marketable title statutes. 17A is not. But again, even with 31, that has the 40 years, that is title. Is that really an easement? I don't think we learned that in property law. An easement is not title. It's part of the bundle of sticks, but title is ownership.
I know your light's running. Chief, may I ask a question, please? As I read the brief, your treatment of 614.15 was, first of all, raised in the reply brief, understandably, because that was in response to the Appellee's raising it. But the counter argument that I see there is that it doesn't apply because it doesn't apply to void transfers, and that's your position on why 614.15 doesn't apply, correct?
Correct, and you know, unfortunately, we don't even have a district court opinion on that. The district court opinion focused on 17A.
Channel et al. Is hereby submitted. And we'll have a brief recess here while the lawyers